Hi, my name is Nicholas Height. I'm a lawyer licensed in Louisiana with over a decade of experience committed to working with adult and child survivors of intimate partner violence, stalking, and sexual assault. This video is only informational in nature, and even though I am a lawyer and I am going to be talking about legal topics, I am not giving you legal advice, and nothing I say in this video should be considered legal advice. If you have questions about anything I talk about or questions about your particular legal situation, you should seek out a licensed and experienced attorney who will be able to provide you with legal advice specific to your needs. In this video, I'm going to talk about the basic operation and procedures of a court hearing on a petition for protection from abuse. Some folks refer to this as a protective order hearing or a restraining order hearing. However it's described, this is the hearing that takes place in civil court when a judge is trying to decide whether or not to issue an order of protection beyond any temporary or emergency restraining order that was previously issued. This is also the same basic framework for a court hearing regarding a civil injunction. It's important to keep in mind this is just the most basic framework, and it's always possible that a case will proceed in a different way based on the unique circumstances of that case. If you have questions about your particular case, you should contact a licensed and experienced lawyer who can provide you with legal advice or legal representation in court. And that brings me to my first point, which is that in civil court, you have a right to representation, but you are not guaranteed counsel like in criminal court. In civil protective order cases, there is no public defender and there is no district attorney either. If a party is not able or willing to obtain legal counsel, they are allowed to represent themselves. Generally speaking, someone representing themselves is obligated to follow all of the same rules and requirements as a trained attorney. Working with a competent lawyer can have a profound impact on the success of your case. Louisiana, like most places, has a public civil court system. That means that nearly anyone is allowed to be in the courtroom for nearly any reason while court is in session. That means your hearing will likely occur in front of strangers who will hear and see everything that goes on in your case. Additionally, anything that gets filed into the court record, including the transcript of the hearing, petitions, and evidentiary documents, will be public records that are accessible to anyone who requests them. It is possible to request hearings happen in a closed courtroom and to have parts of the record sealed, but that is not automatically guaranteed, and that kind of request will have to meet a specific legal burden to be granted. In addition to taking place in a public court setting, hearings generally take place such that the plaintiff and the defendant are in the same room at the same time and have the right to face one another, literally. Because of public health considerations, there has been some variation in that, but you can generally assume that a court case will take place with everyone in the same courtroom at the same time, face to face. This also means that any witnesses will probably need to personally come to court on the date and time scheduled for the hearing. If witnesses will not come to court voluntarily, you can subpoena witnesses or to request certain documents from third-party sources. All of this information gathering is generally described as discovery, and it all must be completed prior to the start of the hearing. If you don't have all of your evidence gathered by the time your hearing is scheduled, you may have to proceed without it. The hearing is not an opportunity for the parties to speak to each other directly, but to speak to the judge so that the judge may make a final determination about the matter. This is particularly true if either of the parties are represented by lawyers and therefore are the designated court advocates for the party they represent. It can sometimes be tempting to simply speak or argue with each other directly in court, but the assumption is that the parties have already attempted to communicate amongst themselves, and that has failed or is not possible for whatever reason, so now everyone has come to court to speak to the judge about the problem and not each other. Assuming that the necessary paperwork has been served on all parties and no one wants to have the matter continued and reset to a later date, the expectation is that the typical restraining order hearing can be completed in a single day. It is possible that the hearing is continued for various reasons, but hearings on a restraining order cannot be continued indefinitely. Once the matter moves forward with a hearing, there are some things you can expect about the process. The law provides for a basic order of events that starts with a presentation from the plaintiff who filed paperwork with the court first. That is then followed by a presentation from the defendant, who may have also filed paperwork with the court. The plaintiff then may be able to provide testimony again under certain rare circumstances. After all parties have made their presentations to the judge will issue a judgment, which may then be the subject of an appeal. I'm not going to talk about the appeals process. I am only going to talk about the events that take place in the local trial court. The first presentation comes from the plaintiff, who initiated the case and filed the first papers that led to the hearing happening. If you've ever watched a TV show or movie about a court case, you may have heard this called direct testimony or being on direct. Generally, this presentation will include testimony from the plaintiff directly. The plaintiff is placed under oath to tell the truth, the whole truth, and nothing but the truth, just like on TV and in movies. If the plaintiff has a lawyer, the plaintiff's lawyer will question the plaintiff about the facts and allegations in the paperwork submitted to the court. Plaintiff's testimony can also be used to identify certain pieces of evidence, like documents, text messages, photos, audio recordings, or other things the plaintiff personally knows about that support their allegations. If the plaintiff does not have a lawyer and is self-represented, the judge may question the plaintiff or may simply invite the plaintiff to provide whatever statement and evidence they think is needed to prove the allegations in the paperwork. Broadly speaking, the testimony from the plaintiff is intended to confirm and prove the truth of any allegations that are in the paperwork filed with the court, and their testimony should generally relate to only those facts and allegations in the paperwork. Once the plaintiff has produced all of their testimony and evidence, the plaintiff is then subject to cross-examination by the defendant's lawyer or by the defendant directly if they are self-represented. Broadly speaking, cross-examination is an opportunity to ask follow-up questions about the information the plaintiff has provided and to attempt to demonstrate any flaws in that testimony. Cross-examination is not intended to be an opportunity to raise new issues that have not been testified to by the plaintiff. The defendant will have an opportunity to present their case later. If any new information came to light during the cross-examination, the plaintiff or the plaintiff's lawyer can offer redirect testimony to clarify or correct the new information that was elicited. In addition to testimony from the plaintiff directly, there can be testimony from other witnesses about what they observed or experienced that can support the plaintiff's case or disprove the defendant's case. As part of all of this testimony, additional evidence can be presented and introduced into the court record to help support the plaintiff's case or disprove the defendant's case. In civil court, the plaintiff typically has the burden to prove that their allegations are true. However, if there are cross-allegations filed by both parties, it may be necessary for the plaintiff to also present a defense to the cross-allegations at the same time. Each witness presented as part of the plaintiff's case will be subject to cross-examination by the defendant or their lawyer in the same way that the plaintiff was. Likewise, each witness can be subject to redirect in the same way that the plaintiff was. Following the testimony of the plaintiff and all of the plaintiff's witnesses, the defendant then has an opportunity to present their case. The defendant's presentation effectively mirrors what I described for the plaintiff. The defendant can provide direct testimony on their own behalf, either via questioning by their lawyer or the court, or by simply producing a statement and introducing evidence as they see fit if they're self-represented. The defendant, just like the plaintiff, will be subject to cross-examination and will have an opportunity to provide redirect testimony following the cross-examination. In the same way that the plaintiff did, the defendant has an opportunity to present additional witnesses and accompanying evidence that they believe supports their claims or disproves the claims of the plaintiff. In the same way that it happened during the plaintiff's presentation, the defendant's witness will also be subject to cross-examination and available for any possible redirect testimony. It is possible that during the course of the defense presentation, new information or allegations are raised. If this is the case, then the plaintiff may have an opportunity to recall some or all of the plaintiff's witnesses to present rebuttal testimony to address only those new pieces of information or allegations. This does not happen often, as both parties usually know what each presentation will look like ahead of time, and each presentation typically aligns with the information in the court paperwork that was filed in advance of the hearing itself. Once the presentation of each side in the case has been concluded, a couple of different things can happen. For a restraining order case, the most common next step is that the judge will immediately render judgment from the bench. Alternatively, the judge may choose to take the matter under advisement, which means the judge will consider the hearing concluded, but will take additional time to review all of the information presented and render judgment later. Because of the immediate nature of a restraining order, this usually only means the judge will take a few hours and then render judgment later that same day. Once judgment is rendered regarding the restraining order, a written judgment is typically rendered simultaneously using forms created by the Louisiana Protective Order Registry and the Louisiana Supreme Court. That judgment is then immediately sent to the statewide registry where it is logged so that it can be referenced by courts and law enforcement as needed. Following final judgment, either party can request written reasons for judgment from the judge. When they are rendering judgment, the judge usually gives some kind of verbal explanation as to why they rule the way they do, but requesting written reasons can provide a more thorough explanation of the judge's reasoning in reaching the final decision. Additionally, following final judgment, either party can file an appeal to have the judgment reviewed by a higher court. In the case of a civil order of protection, any appeal made after an order of protection is issued does not undo the protection. The order of protection will remain in place and full effect while the appeal is pending. Please remember that this information is just meant to be the bare bones of how a hearing can be conducted. In any particular case, there can be variations because of the type of allegations or pleadings that have been filed, because of the judge's discretion over how most effectively and efficiently to run the hearing, and because of any number of procedural issues like delays from crowded court dockets, court holidays, competing and overlapping court cases, or possible settlement negotiations between the parties. Hopefully, though, this video has helped you understand the basic parts of a court hearing when everything goes as planned. Thank you so much for your time and attention for this video.